I seek the leave of the House under Standing Order 349 to make a personal explanation with regards to a number of claims made in this House about my involvement in Canterbury water issues.
Leave is sought for that purpose. Is there any objection? There is no objection. The Honourable David Carter.
Mr Speaker, on 31 March and 1 April, certain incorrect claims were made in this House in relation to Canterbury water issues. This is the earliest opportunity I have had to address these allegations. Firstly, it was claimed that I stood to benefit financially if the proposed Huranui irrigation project went ahead. This claim is untrue. There is an existing historical consent to irrigate approximately 40 hectares of my 1,700 hectare Cat Hill property from the Huranui River. This consent was transferred to me when I bought the property approximately 4 years ago. It has not changed since, and I have no intention of applying for more water in the future. If the Huranui irrigation project proceeds, it will have no impact on the existing historical consent. The Cat Hill property cannot be further irrigated. Therefore, I do not stand to benefit financially, as Russell Norman stated. The issue of minimum flow restrictions is irrelevant. In the entire time the consent has been in my name, the minimum flow rate restrictions, which are triggered at 10 cubic metres per second, have never been in place. To claim, therefore, that I stand to gain some financial benefit due to a greater certainty around these minimum flow rates is simply untenable. Russell Norman then claimed that I had inappropriately intervened in the Huranui water conservation order process. This is also incorrect. Last year, in conjunction with the Huranui Mayor Gary Jackson and Bede O'Malley, Chair of the Canterbury Water Management Strategy Steering Group, I discussed with all parties involved in the Huranui WCO process the possibility of trying to reach a consensus solution, but only after reserving their right to appeal to the Environment Court. This collaborative approach was undertaken with all parties in an attempt to avoid the combative and expensive court process, and reflects the approach recommended by the Canterbury Water Management Strategy. All parties were initially positive about this approach, but subsequently some withdrew support and decided to proceed with Environment Court action. Finally, I would like to address my answer to written question 14809. The question was received in conjunction with 19 other very similar written questions from Russell Norman. In the context of these other questions, I interpreted question 14809.
Point of order, Mr. Speaker.
It's with some regret that I interrupt a personal explanation, sir, but this has now gone to the point where the Minister is explaining a ministerial response, an answer to a question to a minister, and that can't be a personal explanation.
The personal explanation is the way.
Speaking to the point of order,
I'll hear the honourable member on the point of order.
I think if I'm allowed to carry on for another minute, it would explain the situation completely to the satisfaction of Mr Mallett.
The point of order the members raised relates to making a personal explanation about an answer given to a question. I think were the question being sort of technically corrected by a minister, the member would have a fair point, I think. But I think I suspect what the minister is going to say relates to well, I don't know exactly what he's going to say, but if it relates to why he personally, how it relates to him personally, then I think it's in order. The Honourable David Carter, allow the member to continue.
Finally, I would like to address my answer to written question 14809. The question was received in conjunction with 19 other very similar written questions from Russell Norman. In the context of these other questions, I interpreted question 14809 as asking if I had discussed with any parties the suggestion of not appealing to the Environment Court. This was certainly not the case, as I had urged all parties to lodge an appeal to protect their position in the interim until a consensus solution could be reached. I therefore answered no to the question. In hindsight, I can appreciate that this answer was not as clear as it possibly could have been, and I do apologise for any confusion that it may have caused. However, as I have explained, I entirely refute all allegations made by Russell Norman in this House on 31 March and at 1 April. Thank you.
Are there any petitions?